Okay, my clock says 6:01, so let's go ahead and get started. Welcome once again to another Inns of Court meeting. I think I'm starting to get used to only being able to do meetings on Zoom or Microsoft Teams or some other platform. I long for the days where I'll actually get to stand in a room of more than two people and be able to talk about topics that are of interest, like the law and how we can make it better. But I want to thank those of you that have logged in this evening for this topic, especially this evening. I noticed some people had some questions that are listed in the chat. So if something comes up that you think about, because there's only a handful of us, as you can see, that are on the screen, everybody else is muted. So you can't speak out and ask your question, but you can type it into the chat or the Q&A down at the bottom below our pictures on the front screen, and then we'll try to answer any questions that come up. And with that, I'm going to turn this over to Joe Stein, who's going to introduce to everyone our speaker, since they used to work together. Joe, back to you.
Thank you, Judge, very much. Colleagues, we're going to be wading into one of the most controversial issues in our current national dialogue, and that is the issue of police practices in predominantly Black communities. We're going to focus, obviously, on the legal issues that are pertinent to the national debate. We all understand we are not a political organization. We are not an advocacy group. We're an association of legal professionals that have a very diverse political feelings and opinions. We're not trying to change any of those. We're simply going to talk about some of the legal issues that have arisen from the national debate concerning police practices, use of force issues in predominantly Black communities. And unless you've been living under a rock for the last several months, I think we've all heard on the news the debates and the actions and the protest regarding these issues. We have fortunate enough to have a speaker tonight who is one of the state, if not national, experts in police use of force and law enforcement standards. He's conducted numerous trainings on use of force and police practices through police agencies in many parts of the state and outside of the state. He's conducted dozens of due process hearings regarding police conduct, and he has extensive trial experience on federal civil rights cases under 42 USC 1983. He brings a very impressive resume to us tonight. I'm just going to highlight a couple of the items in his career path. He was a deputy district attorney for the county of Riverside in the mid-1980s. He was the assistant city attorney and later the city attorney for the city of Oceanside. He was there for 11 years, ending in 2002. That's when I had the chance to meet him. He was my boss, but more than my boss, he became my friend, my colleague, and I thoroughly enjoyed getting to know him and learn so much from him, as you're going to learn much from him. I had the privilege of working with him for 11 years. He went on from the city of Oceanside, left the city attorney's office, and he was the port authority down in San Diego, the general counsel, for 9 years before going into private practice. And he is currently an attorney, arbitrator, mediator, and hearing officer in private practice. His presentation tonight will be focused on civil rights liability issues, excessive force issues that have taken stage in our national dialogue in recent times, starting with the death of George Floyd earlier this year at the hands of the Minneapolis Police Department. So we're going to touch on some issues that are politically sensitive, but again, we respect everybody's political views. We're going to talk about the legal issues that arise from these very sensitive political issues. So speaker today, he's going to start by sharing some personal experiences he has had with regard to overzealous police practices, but then he's going to spend the bulk of his time talking about legal issues regarding use of force and highlighting things that couldn't be more relevant, issues and controversies that have arisen in our national dialogue just this year. So he's going to be talking about them. Final thing before I introduce him is if you have questions, You can go ahead and type those in. He would prefer to be able to give his presentation without being interrupted, but at the end, after 40, 45 minutes, he certainly would be willing to take some questions, and if you'll kind of type them in, I'll monitor it, and we'll hopefully have time for 2 or 3 questions. So with that in mind, it's my privilege and honor to introduce my friend, an expert in police law enforcement practices, Mr. Duane Bennett. Duane?
Thank you, Joe, so much. Thank you. You're so kind. I appreciate the opportunity to speak to you tonight about this very, very controversial and pertinent and very, very personal subject. I have so many thoughts that go on through my mind in terms of law enforcement. I want to start out by saying this. I'm one of the few African-American attorneys you'll find that has represented police departments. I've had 5 police departments that I've represented as in-house counsel, and so I love law enforcement. I'm not one who has ever attacked law enforcement. I love law enforcement. But a lot of the issues that we see today are troubling, and they're troubling from many standpoints. And I speak tonight to you as a police attorney who's defended law enforcement agencies, as well as a police attorney who's been involved in civil rights lawsuits against law enforcement agencies. And I just want to start by telling you, Joe mentioned that I was a deputy city attorney. I started my career back in the 1980s. I guess I'm pretty old now. And I became a member of the bar in 1983. Well, in 1985, I was a prosecutor for the county of Riverside when I had my first encounter with law enforcement. And I grew up in South Central Los Angeles, but I worked in Riverside. Man, I commuted for a while. And one night coming from a church meeting, it was around 9:30, I was traveling on a major highway. And I saw LAPD in my rearview mirror. And I said, oh boy, the police are back there. So, the police are there, you pay very, very careful attention to how you drive. Well, while I saw LAPD in my rearview mirror, I saw 2 units with their wigwags approaching me. And they were approaching southbound, I was going northbound. So I just pulled over to the right to let the emergency vehicles pass, I thought. Little did I know they were coming for me. When I stopped and pulled over to the right, I got lit up from behind. And I said, oh my goodness, now I'm going through all my district attorney stuff. Man, did I violate vehicle code section 22-350 or vehicle code section 21-453? What is it? I couldn't figure out what I had done wrong. So I started to reach for my ID, or actually for my registration in the glove compartment, when I heard the police say over the loudspeaker, put your hands on the steering wheel. Thought that was a little strange. And then they said, roll the window of the car down slowly, which I did. Open the door of the car from the outside. I opened the door, get out of the car. I opened the door, and as I got out, I realized the first thing that came in my mind was I might die tonight. And the reason I said that was because I saw police officers with their doors open on one knee, 2 shotguns and 4 revolvers, all pointing to me. I didn't know what I had done. I was disoriented. Put your hands on your head. I put my hands on my head. They grabbed my arms, jerked my arms. They handcuffed me very, very tightly. Then they pushed me up against the side of the wall. My car was just parked in the middle of the street. Pushed me up the side of the wall and put a gun to the back of my head. I had said absolutely nothing. I was so dazed and disoriented, I didn't know what to do, but I was calm. And to this day, I submit to you that if I had made what we call a furtive gesture, I would have died that night. I was happy when they took me from the curb or took me from the wall and basically threw me to the curb. I fell face first. Of course, you can't do anything when your hands are behind your back. There's no way to really gently fall into the asphalt. So I fell face first. And that was my first experience and the first indication to me that driving while Black and Black Lives Matter is a real issue. You see, I had never had a problem with the law. I had figured that, hey, you keep your nose clean, don't contract or don't get into any conflict with law enforcement. My father gave me the talk and I honored it. I went to school, I became an attorney, I became a prosecutor, but it still didn't spare me from almost dying that night. LAPD would ultimately just keep me on the curb. They wouldn't, when I asked them, I finally came to my senses and asked them a question. They told me to shut the F up. They never checked my ID. They never told me why I was arrested that night, why my civil rights had been violated. And when I finally was released, there was something muttered about you fit the description. Well, in hindsight, I realized, of course, I fit the description because for Black people, the description is always the same. I filed a claim against the city for false arrest and deprivation of civil rights. They denied the claim and never even sent me a note of apology. So when you hear the slogan and when you hear people say Black Lives Matter, I realized that night my life didn't matter. They didn't care who I was. The fact of the matter is, I was a Black man. They didn't have to justify why they did this to me. And at the time, not only was I the wrong Black man, I was coming from church, I was in a Honda Civic, and I was a prosecutor. I was on their side, but I'm still Black. Life didn't matter, not even an apology. So when I see the cases today, it just harkens back and reminds me as to how far we still have to go. And it made me want to get on the inside and become a police attorney because I said, you know what, these folks really need help. They need help. There's something seriously wrong with the system. Well, I left from being a prosecutor to I went actually to the city of Santa Ana where I became the attorney for the Santa Ana Police Department. And that's where I really learned the law or really became familiar with the law of civil rights. And I want to just tell you from the standpoint of what you see today with all the cases that we'll call Black Lives Matter cases, George Floyd, Breonna Taylor, Ahmaud Arbery, Rodney King, they all stem and they all have to be viewed within the context of the federal civil rights statutes. 42 USC section 1983 is a civil rights statute that comes into play when we have use of force cases or when we have these wrongful death cases that we see. If you look at 1983, it says that any governmental actor who acts under color of authority that violates the fundamental rights of another is liable for a civil rights violation. Many times when people hear the term civil rights, they assume that we're talking about Black and white. And yes, that can be a factor. But a civil rights violation takes place when a governmental actor, such as a police officer, violates a fundamental right of a citizen. It could be white versus white, Black versus Black, women versus woman versus man. It doesn't matter as long as you're a governmental actor and you violate a fundamental right. Well, in the case of excessive force cases, whether we're talking Rodney King, Tamir Rice, George Floyd, Michael Brown, Rayshard Brooks, Jacob Blake, in the case of when we're talking about these cases, we're talking about the fundamental right being deprived being the Fourth Amendment. Because the Fourth Amendment guarantees every citizen the right to be free from unreasonable search and unreasonable seizure. Our courts have defined excessive force cases and these wrongful death cases as unreasonable seizures of the person. So when you have police and you have that action, you have a civil rights violation. Now, where the Department of Justice can prove that an officer acted with intent to deprive a person of civil rights because of that person's color or ethnicity, now you can have a criminal civil rights violation under Title 18 USC Section 242. But that and those charges can only take place if the Department of Justice deems it appropriate. When we look at the Fourth Amendment and what it says about excessive force and use of force, the courts define use of force technically under the standard that was enunciated by the Supreme Court in a case called Graham versus Connor. And Graham versus Connor outlines several factors that we consider to ascertain whether or not an officer's use of force crossed the line. The courts say that the use of force standard is based on objective reasonableness, meaning that typically speaking, when we're dealing with 1983, an officer's state of mind has no relevance. If the officer's use of force was objectively reasonable, the use of force can be deemed appropriate. If it's objectively unreasonable, there's a problem. But the courts, when they look at this Graham versus Connor standard, and when we get into a 1983 litigation, they analyze several factors, such as the need for the officer to make a split-second decision, the threat that the suspect or the victim posed, whether or not the suspect or victim was a flight risk, whether or not there was a need to protect or defend life, whether or not the officer had a fear of his or her own safety. The courts look at all these factors and then they ask themselves whether or not a reasonable officer confronted with the same circumstances would have used the same degree of force. Okay, that's the standard. And that's a standard that when you look at these cases, whether it be, and the reason I throw Ahmaud Arbery in there, I'll explain to you why I throw Ahmaud Arbery into one of these civil rights cases, because even though it took place at the hands of vigilantes, there's still a question as to whether or not there was government involvement in the Ahmaud Arbery killing. But when we look at cases, and when we look at these civil rights cases, you analyze them from the standpoint of 1983, the civil statute. And when you apply the Graham versus Connor standard, you're going to have a lot of questions if you're really, really objective and you look at the cases, honestly. The courts have also stated in cases such as in a case entitled Diorly, the Diorly case, the court said that before an officer uses an escalated degree of force, the officer should warn. In a case called Yang versus Hardin, the court said that if police officers are on the scene and they see a civil rights deprivation taking place, they should intervene. Now, you didn't see intervention in the George Floyd case. And in the first true, in my estimation, Black Lives Matter case, Rodney King versus City of Los Angeles, you didn't see intervention. Now, see, I was one of Rodney King's civil rights attorneys. And if you go back and you look at the 1991 beating at the hands of LAPD, you'll see an African-American man, Rodney King. We called him Glenn. His name was Rodney Glenn King. He fled from police. He was wrong. They took him, or he took them on a pursuit. And when they stopped him and when they caught him, they beat him like you've never seen a person beaten before. And see, African Americans have been complaining about interactions with police for a long time, but this was the first time that it was caught on camera. And you could see police beating him over and over and over and over again. We asked him, hey, Glenn, why did you keep getting up? He said, they told me you better run. He said he feared for his life. And he said after a while, they beat him so hard and they beat him so much, he couldn't do anything else but move. Every time they strike him, he would just move out of reflex, just trying to protect himself. And the sad thing about Rodney King was he was beaten, but there were a ring of officers, approximately 20 officers who sat around the perimeter and did nothing but watch. Sort of like the officers in the George Floyd case, who didn't intervene from an obvious civil rights case, while Mr. Floyd laid prone on the ground and officers surrounded him and cameras were running. This officer, Derek Chauvin, had the gall, in light of the Fourth Amendment, in light of equal protection, the 14th Amendment, which guarantees everybody the freedom to be free from unequal application of law and deprivation of due process. Chauvin had his knee on the neck of Mr. Floyd for 8 minutes and 46 seconds and had his hand in his pocket. He obviously wasn't trying to overcome resistance because Mr. Floyd was no threat. An officer stayed and they laid on him while this man begged for his life, while he urinated on himself, called for his mother, and narrated his own murder. I've represented police for a long time. Couldn't have been more disgusted, angered, ticked off at what I saw, because they can do better than that. And we see this scene playing out over and over and over again. If we go through the list of cases, and I don't have a lot of time, and so I ask you to please forgive me for being cursory going through some of this information. The information is so important. Don't have a lot of time, so I do the best I can. But as we go through some of these other cases, and we look at cases, for example, Ahmaud Arbery, and you'll say, well, where is the government involvement in Ahmaud Arbery? Well, if you go back and look at the case, there was a law enforcement officer who texted the owner of the property that apparently Ahmaud Arbery was snooping around, and said, hey, if you have a problem, you guys, you need to contact this guy who happened to have been one of the vigilantes who tracked Mr. Arbery down and killed him. Now, Mr. Arbery was minding his own business. He's jogging. He had a right to jog. Did they have a right to chase him down, encounter him, cut him off, and ultimately kill him? People say, well, you know, all lives matter. You can't say Black lives matter. All lives matter. How do all lives matter when you see that type of conduct? You know, I was talking to a buddy of mine. His heart is great. He's a great guy. But I was talking to a buddy of mine, and he was telling me, when we were talking about Black Lives Matter, well, all lives matter. I said, you know what, I agree, all lives should matter. It just doesn't seem like they do. Not in this nation, not when we see the cases we see. Now, let's talk about Jacob Blake. This is the Kenosha killing, or the Kenosha shooting. Thank God he did not die. But in that particular case, law enforcement sees him as he walks towards his vehicle. Okay, there are several officers on the scene. Why not push him out the way? If you were concerned about him getting in the car, why let him get in the car and then casually go around his door and pump 7 rounds in his back with his children in the car in a confined space? You know, police officers are taught defensive tactics. They're taught to use tasers. They're taught to use batons. They're taught to bum rush. Why would you allow him to get in the car and then reach around the car and shoot him 7 times in his back? You know, if I'm the defense attorney for that department, I have a problem with that. What about other cases? In terms, for example, in the Rodney King case, it was an interesting case. That was clearly wrong. That was clearly a deprivation of civil rights. That was clearly a violation of equal protection. But when you see the hysteria and you see the unrest and you see people upset because they believe that justice has not been served, I understand it. I understand it. Because even in the Rodney King case, where we had video evidence that showed him being unmercifully beaten, when that case went to trial in Simi Valley, the jury, seeing all that evidence, acquitted all officers. Nobody was charged. They were charged, nobody was convicted. And that was a case where the federal government and Department of Justice did what the Department of Justice should do. These civil rights laws came out of the Black codes. They came out of the cases that we used to see in Alabama, et cetera, where George Wallace would stand on the steps of the school and say, these Black kids aren't coming in here. Well, okay, if the state's not going to enforce the law, the federal government has to come in and do it. And typically speaking, the federal government will give the state a chance to take care of their own business. Okay, in Rodney King, the federal government stood back and said, okay, we see that travesty. Go ahead, state, take care of it. The state tried Mr. King and acquitted the state tried the officers and acquitted all of them. At that point in time, President Bush said, you know what, I don't like that. I'm going to refer this to the Department of Justice. And the Department of Justice came in under 18 U.S.C. Section 242 and brought federal charges against officers and convicted a couple of them. That's the Department of Justice doing what the Department of Justice is supposed to do to enforce the constitutional laws of the land. And in the Rodney King case, it was very, very interesting. The Department of Justice is typically on the side of law enforcement. In that case, they were not on the side of law enforcement. They actually worked with us, the plaintiff's attorneys, trying to sue the city of Los Angeles. We gave them information, they gave us information. So it was back and forth. They needed access to Rodney King. Rodney King, the civil team was cheering them on and they were cheering us on. It was a very, very interesting dynamic. It was interesting to see that litigation from that standpoint, particularly from the standpoint of somebody who always represented law enforcement. And I love, just like I say to this day, I love law enforcement. I won't turn on law enforcement unless I see injustice. And if somebody brings to me a case that is unjust or something that is clearly a violation, I feel it my duty as an attorney, as a member of the bar, to stand up and to say injustice is wrong. And I don't care if it's on behalf or against a city or against a police department, I think it has to be done. And I do it. Excuse me. So in the Rodney King case, we saw the state take a run and the state missed. Now let's talk about Breonna Taylor. Excuse me. The Breonna Taylor case is probably, in my estimation, one of the saddest cases out there now, because Ms. Taylor did nothing. And I look at the controversy behind what's going on with the grand jury and whether or not the grand jury decided the case correctly. You know, Ms. Taylor's attorney sued under, or basically had a 1983 cause of action there. They settled the claim with the city for $12 million. And they did what you can do through civil rights actions. You know, number one, when you bring these civil rights actions and you settle them, not only do you get paid or do you get compensation for your client or for the victim of a civil rights deprivation, but there's an attorney's fees provision that motivates attorneys to bring these lawsuits. That's 42 USC section 1988. And in some cases, when you do prevail as a civil rights plaintiff in these cases, a court will ascribe a multiplier, you know, depending on the complexity of the case. I've had that, and I've been involved in cases like that. You don't want to go into a federal court on a 1983 case where you have a bad case, because if there are damages awarded, punitive damages are likely, and there are huge attorney's fees. So a lot of these jurisdictions will settle these cases. But the beauty of settling a 1983 case is not only from the compensatory standpoint, you can actually make some, or you can actually settle upon some reforms to a department. So in the Breonna Taylor case, they settled, you know, upon some, I don't know exactly what the reforms were, but a part of the settlement agreement apparently included reforms. That's a good thing. And that's a good thing, particularly when the criminal justice system does not work in some of these cases. I'm just amazed at what's going on in the Breonna Taylor case, because it's so messed up. See, you know, the whole notion that, and I'm glad she settled. I'm glad the estate was able to settle and get civil damages from that case. But in these criminal cases, and in these cases where, for example, a prosecutor brings a case before the grand jury, hey, the grand jury is a tool of the prosecutor. I mean, this is not, you know, when you go before before you go before the grand jury, that's not a due process setting where you have, you know, the prosecutor and the defense attorney in there. No. That's a one-sided setup. That's a one-sided deal where I, as a prosecutor, go and present my evidence before the grand jury, and I tell the grand jury what I want them to know and what I want them to hear. And they come out with an indictment, and from a prosecutorial standpoint, I know people may disagree with me, takes the prosecutor off the hook, because the prosecutor can say, hey, the grand jury didn't see it fit to issue an indictment. You know, that's what happened in the Breonna Taylor case. But in the Breonna Taylor case, there's all kinds of contradictions. You know, we're supposed to believe in the Breonna Taylor case where an innocent woman was killed. We're supposed to believe that law enforcement went and got a no-knock warrant. A no-knock warrant is so that they don't have to knock. I've been on no-knock warrants with police. I've gone on a SWAT car and put a flap jacket on because I wanted to see how they executed these no-knock warrants. I hung on the side of the car while they drove through the city. And what they did was they would go up to a residence, throw a flashbang, a device that explodes. They throw that through the window, it explodes, and they go straight in the house. They don't knock and say, you know, police. I mean, why would you get a no-knock warrant if you're going to announce yourself? The reason to get it is because you're concerned that somebody's going to destroy evidence, or they're going to be a danger to you, or they're going to flee. A no-knock warrant is so that you have the element of surprise. Well, in the Breonna Taylor case, they execute the warrant at midnight. And I don't blame, you know, who's going to blame somebody if somebody knocks on your door and they come in, which is what apparently a witness said, or one of the persons in the house said, that they knock, they didn't announce themselves, they go in. I don't know who they are. I think they're here to harm me. I fire one round, and the police fired at least 30 rounds in return, and they killed Breonna Taylor. The irony of it also is that the only person in the Breonna Taylor case that got indicted was the officer who did not kill her. We know that the man who got indicted didn't kill her. The other two who did, nothing happened. I submit to you, and I submit as I talk to particularly African-American folk who are upset about it, I said, look, The criminal justice system routinely and consistently has not always worked for African Americans. So you can't freak out and you can't go crazy when you see some things like this happen. But I love the fact that we have 42 USC section 1983, because at least you can get damages. Perhaps you can get punitive damages, and perhaps you can get some reform from bringing these civil rights actions, and maybe it'll change police departments. So I know that my time is very, very short, but I wanted to touch on one other issue just before I close. In the Breonna Taylor case, there's a controversy over qualified immunity. Qualified immunity, if you don't know, is an immunity from lawsuit. It's controversial because it's almost like a quote unquote get out of jail free card. Qualified immunity applies where the law is not clear, where an officer didn't know whether or not his or her conduct was constitutional. And in essence, it gives an officer a pass where they violate constitutional rights, where that right has not been clearly established. It's controversial because it may be used as immunity against a civil rights lawsuit. In the case of Breonna Taylor, you hear people saying qualified immunity should not attach. It should not apply because this was a clearly known violated right, because the Breonna Taylor case was so wrong. It just seems like it was so wrong on so many sides. Even the SWAT team has criticized the department for how they executed that, how they did it. And it brings me to something that I want to say to you. One of the Graham versus Connor factors that courts consider when they evaluate use of force is degree of threat or harm that could potentially come to the officer or come to the public. That's really a subjective factor. You know, when I was defending police, and I've defended several officer-involved shooting death cases. I've defended several cases where police officers have used excessive force. It's music to my ears when I get in there with those officers and I say, hey, did you feel threat or were you threatened? Yes, 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 I feared for my life. Okay, there you go. Once I hear an officer say they feared for their safety, I know that under Graham versus Connor, you have something that you can use to defend yourself. But sometimes that stuff isn't true. Sometimes when an officer says, I fear for my safety, are they saying it because it's true or are they saying it because it's false? We don't know all the time. But one thing I can tell you is when we talk about biases within departments, as an African-American attorney, I'm one of the few that represented police departments. I had my own challenges when I represented police. Some of them didn't respect me. They thought I was some joker off the street. They didn't care about me. And really, it's because of the color of my skin. I'm sorry to say. I hate that, you know, and Joe will tell you, I didn't play, quote unquote, the race card when we worked together, but it is what it is. You recognize that some people just don't respect you and some people have challenges with you. But I will say this. I always ask when I see these large use of force cases or these wrongful death cases, and when I hear police officers say they feared for their safety when they confront these situations, whether it be Laquan McDonald, whether it be Rashard Brooks, who got shot in Atlanta, whether it be in the Breonna Taylor case, et cetera, I always ask the question, what is the color of fear? And does fear have a color? Is the color of fear black? Because in Breonna Taylor, they said, well, we saw a dark object moving and we just start firing. You know, in the Michael Brown case in Ferguson, the officer said, well, this man was a big brute. He came towards me, he challenged me. Is the color of fear black? You know, I don't mean to get into politics at all, but I just have to say this because it's so apropos. After the vice presidential debates, the president called Kamala Harris a monster twice. Okay. That's like a gorilla who's been called thugs. You know, are we people? Does your life matter? And do officers inherit this intrinsic idea as to blacks being threat? Is the color of fear black? If it is, then you can see why the statistics show from 2015 to 2020 that African Americans are 3 times as likely to die in an officer-involved shooting as whites. We represent 13% of the population, but we're killed at 3 times the rate. Why? Is the color of fear Black? You know, in the Stephon Clark case in Sacramento, California, police saw him involved in some suspicious activity. They chased him to his grandmother's yard. He turned around, he held up a cell phone. They thought it was a gun and they killed him. So in the hands of a Black man, does a cell phone become a gun? Is the color of fear Black? I just like to say and close by saying this, the Kyle Rittenhouse case in Kenosha is a very, very interesting scenario. Because here's a young white man, 17 years old, walking down the street with a long arm or a long rifle. Nobody stopped him. As a matter of fact, when police did confront him, they thanked them for being there, offered him water. What if Kyle Rittenhouse had been Black? And what about the Dylan Roof case? Dylan Roof was a young white man who went into a South Carolina church. Approximately 10 people there. They were praying. They were involved in Bible study. They welcomed him in. They prayed with him, studied the Bible with him. In turn, he murdered 9 of them. 9 African Americans. Left 1 to go back and tell what he had done. When police confronted him and when they arrested him, don't take my word, look at it for yourself. When they confronted him, they arrested him. Interesting. Here's a guy who murdered 9 African Americans. He had to have been armed and dangerous. But they approached his car to arrest him. They took their guns out, but as they got closer, they put their guns, some of them put their guns back in the holster. Why would you put your gun back in the holster from somebody, you know, and when you're getting ready to arrest somebody who just murdered 9 people? But he was a young white man. They took him to Burger King on the way to the station because he was hungry. Would that happen in the case of an African American? So I ponder these questions often. A lot of what I see disturbs me. And it harkens back to what people say when they talk about Black Lives Matter. I just want to close by saying this. I know sometimes people, you know, particularly as African American, I'm always sensitive to people believing that you're saying this because it's a Black thing, et cetera, et cetera. But, you know, I think that the question as to whether or not African Americans' lives are valued or devalued is a real fundamental issue for all lawyers, all attorneys, all courts. And just to show you that, or just to show you this, Joe's daughter just became a member of the Washington State Bar. And she was a little girl when Joe and I worked together. But it's ironic that she became a member of the Washington State Bar because on June the 4th, 2020, the Supreme Court of the state of Washington penned a letter to all members of the court and the judiciary. And I'd just like to close by reading this letter to you. It says, "Dear members of the judiciary and the legal community, we are compelled by recent events to join other state Supreme Courts around the nation in addressing our legal community. The devaluation and degradation of Black lives is not a recent event. It is a persistent and systematic injustice that predates this nation's founding. But recent events have brought to the forefront of our collective consciousness a painful fact that is, for too many of our citizens, common knowledge that injustices faced by Black Americans are not relics of the past. We continue to see racialized policing and the overrepresentation of Black Americans at every stage of our criminal and juvenile justice systems. Our institutions remain affected by the vestiges of slavery, Jim Crow laws that were never dismantled, and racist court decisions that were never disavowed. The legal community must recognize that we all bear responsibility for this ongoing injustice, and that we are capable of taking steps to address it if only we have the courage and the will. The injustice still plaguing our country has its roots in the individual and collective actions of many, and it cannot be addressed without the individual and collective actions of us all. As judges, we must recognize the role we have played in devaluing Black lives. This very court once held that a cemetery could lawfully deny grieving Black parents the right to bury their infant. We cannot undo this wrong, but we can recognize our ability to do better in the future. We can develop a greater awareness of our own conscious and unconscious biases in order to make just decisions in individual cases And we can administer justice and support court rules in a way that brings greater racial justice to our system as a whole. As lawyers and members of the bar, we must recognize the harms that are caused when meritorious claims go unaddressed due to systematic inequities or lack of financial, personal, or systemic support. And we must also recognize that this is not how a justice system must operate. Too often in the legal profession, we feel bound by tradition and the way things have always been. We must remember that even the most venerable precedent must be struck down when it is incorrect and harmful. The systemic oppression of Black Americans is not merely incorrect and harmful, it is shameful and deadly. Finally, as individuals, we must recognize that systemic racial injustice against Black Americans is not an omnipresent specter that will inevitably persist. It is a collective product of each of our individual actions, every action, every day. It is only by carefully reflecting on our actions, taking individual responsibility for them, and constantly striving for better that we can address the shameful legacy we inherit. We call on every member of our legal community to reflect on this moment and ask ourselves how we may work together to eradicate racism. As we lean in to do this hard, necessary work, may we also remember to support our Black colleagues by lifting their voices. Listening to and acknowledging their experiences will enrich and inform our shared cause of dismantling systemic racism. We go by the title of justice, quote unquote, and we affirm our deepest level of commitment to achieving justice by ending racism. We urge you to join us in these efforts. This is our moral imperative, and it was signed by all 9 justices of the Washington State Supreme Court. Thank you.
Wayne, that was outstanding. I can't thank you enough. Ladies and gentlemen, if you have any questions, we have a few minutes, I believe, Judge Washington, if you wouldn't mind, that perhaps Duane can respond to a few questions. You can type them in, and on my screen, I can see them there. I see clap, 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 and I wish you were all together because I think that deserved a standing ovation myself, but we can't do that here. So if anyone has questions to submit, I would be glad to review them and forward them to Duane. Also, Duane has a PowerPoint presentation that he loosely followed in his presentation tonight. We will make that available electronically to all members. So if you want to see that, again, he followed it loosely. He had a tremendous amount to cover, but it will be made available to everybody here tonight. Okay, I'm getting right presentation. Duane, I had one question as a follow-up on an issue that you wrote, that you raised, that I was curious about. In the George Floyd tragedy, where we had officer, I think his name was Chauvin, that was put his knee on the neck of this man. You made reference to officers have a duty to intervene. As I recall, there were, I believe, 3, perhaps 4 officers there who watched the spectacle. My understanding is that these officers were rookies, fairly of a junior level, and then that, unfortunately, Officer Chauvin was a supervisor. My question is, the law in terms of intervention from an officer seeing another officer engage in excessive force conduct, does it factor in whether they're rookies or less senior than the officers who's perpetrating the excessive force? Is that considered at all?
Yeah, Joe, I'm sure it does. And I know that the officers, council who represent the junior officers are making it an issue. Supervisors clearly are held to a higher standard. And under, when in the rubric of 1983, there are a whole plethora of actions that specifically apply to supervisors because they should control the scene. And so I'm sure and I'm certain that the officers are going to argue that they still have an obligation to intervene. As police officers, they still should intervene, but the supervisors are held to a higher standard. And for example, in the Rodney King case, the federal government, the Department of Justice, was able to convict Stacy Coon, who was a sergeant on scene, and the officer who beat Rodney King, but they were not able to gain convictions or to get convictions of the other 2 who stayed on the perimeter or any of the other officers on the perimeter. The other thing I'd say is under 42 USC section 1985, there is a violation or people, governmental actors are liable for conspiracy to violate civil rights. So that can factor into these cases where officers stand on the perimeter. But I would say that I'm certain that if I'm the attorney for the junior officers, of course, I'm going to argue that. That still should not absolve them totally, but I'm sure they're going to argue that. And the supervisors are typically held to higher standards. So they're an easier target than the junior officers would be.
Thank you. Duane,
Wait.
I did have, go ahead, Judge Rushing, go ahead.
Let me follow up. There was a question that was asked for you, Duane, and that's going back to Breonna Taylor and the officers that fired into her apartment and ended up killing her. Do you think that those officers should have been indicted, and if so, for what crimes?
Well, that's a good question. I don't know enough about the specifics to say yea or nay. If I were, here's why I would drill down from a discovery standpoint. And if I were making a case against those officers, here's what I would think about. Number one, when we talk about implicit bias, and when we talk about wanton and willful and just ignorance, I would ask them why they were grossly negligent, if nothing else, in going to that house at midnight and then indiscriminately firing into that house. I think if I were a prosecutor, and I don't know the law in Louisville, Kentucky, where the killing took place, I can't tell you what the state statutes are, but it's almost like you just decided to go into somebody's house and open fire. So whether it's assault with a deadly weapon, whether it's manslaughter or something of the sort as we would construe it here in California, I really, really think that something else is missing here. And here's a question for the Department of Justice, because at this point in time, since the state has decided they're not going to prosecute, the only entity that could come in and possibly prosecute would be the Department of Justice. And here would be the question for the Department of Justice as to whether or not there was a federal civil rights violation. Did those officers, in depriving her of her life, act pursuant to a mental state that would indicate that they had a bias or that they didn't care about her, they subjected her to cruel and unusual punishment because of her color, her ethnicity? I mean, here, when you look at these cases, how apt would it be for some officers like that to go into a rich home in Del Mar and do the same thing? Would they break into a house in Rancho Santa Fe in the middle of the night, and then if they're confronted with one round, just start indiscriminately firing? Yeah, I don't think so. And here's the other thing. Police officer personnel files, for example, in California, and Judge Washington knows this, are subject to pitches motions. They're subject to confidentiality. You can't get to them without bringing a special motion and without showing good cause and going in camera, et cetera, et cetera. But I don't know what was in those officers' jackets. Now, what if one or more of those officers had problems with African Americans in the past? Maybe they have an extra. There are questions about Derek Chauvin in the George Floyd case, having a problem with Mr. Floyd. So if these officers have something like that in their mindset, that militates towards a charge, at least under 18 U.S.C. Section 242 of the federal statute.
Great, thank you, Duane. Another question we have in the Q&A is, since you worked on the Rodney King case from that time and that case back in the early 90s to now, do you see that there's been beneficial progress with law enforcement at all?
Oh, that's a good question. You know what? That's why I got into it. And I think we've made some changes. All right. But what I don't understand is why law enforcement is so slow to adapt. For example, look, why are we still using the carotid restraint? I mean, in the Rodney King case, the city of Los Angeles and the LAPD was one of the first to stop and ban the chokehold. But if you remember, if you go back and look at the Eric Garner case, they choked him out. Remember this? George Floyd wasn't the first time we heard "I can't breathe." That was Eric Garner, where he was subjected to the chokehold, the carotid restraint. And I don't understand why law enforcement has not adapted to that. We have learned some things from Rodney King. And the Christopher Commission came in and really dissected the Los Angeles Police Department. I think a lot of the practices that were so frequently and so cavalierly allowed. For example, if you go back and look at the Christopher Commission and the Rodney King case, you saw all kinds of racist stuff. It wasn't me making it up. All you had to do was analyze what the police officers were saying to each other and how they devalued Mexican lives, or brown lives, and yellow lives, and Black lives. And a lot of that stuff was rooted out. We have learned some things, but I think the progress has been far too little, and it's been too slow. And there's a whole litany of issues related to law enforcement. And I will say this: politicians are a big problem. The politicians who chase police support undermine a lot of police departments' abilities to get their arms around problematic officers. A lot of times you have problematic officers is because the union will fight as hard as they can to make sure those officers are not subject to discipline. And if the chief of police tries to get at them, then the union will go to their political supporters, whether it be the city council, the board of supervisors, and a lot of times back the police chief off. So there are problems. There has been progress, but the progress has been too slow, in my estimation.
Great. Thank you, Duane. I'll turn it back to you, Joe.
Yes, I'm looking to see one of the questions, incidentally, we had was whether you, in your experience, police unions sometimes obstruct officer discipline. And I think you kind of alluded to that just a minute ago. And I guess the answer you'd answer would be sometimes. Is that right?
Yeah. I'm not against officer association because they're right sometimes. Right. There are times when the department is out of control and when the chief missed it, just totally out and out missed it. And you have to have that check and balance. My problem with law enforcement, it's always been my problem, is that they have a lot of times, and too often, police officers have you're all for us, you're for us all the time, or you're against us all the time. And you saw that in the Buffalo case where the police officers, and this was a white man, the elderly white man, he was pushed by law enforcement. He hit his head and he started bleeding out of his ear. And the police officers went by him. And when the chief of police said, "Hey, come here, we need to talk about that," 57 officers resigned from the unit because, how dare you, chief, try to correct us for that aberrant conduct? So that's, in cases like that, I think the union does a disservice to law enforcement. And so at times they can be problematic. At other times they're right. So sometimes equation.
Okay. Thank you. I don't see any more questions, Judge Washington. I think I'll turn it back to you to perhaps close the meeting.
All right. Thank you. And thank you, Duane, for taking time out of your day. This is one of the most topical national things that we are discussing as a country. It's something I probably don't need to say to many people in our end that I've dealt with personally. I've got experiences that aren't very different than yours. I smiled when you used the phrase "the talk," because that's a phrase that is a simple 2 words that means everything in the Black community, and now more so in the Hispanic community as well, on how to survive encounters with law enforcement. And I'm like you, I'm a big supporter of law enforcement. I started my career as a prosecutor, and I recognize that we have a role to play in the system to try to make things better for all of our citizens, not just those that are most fortunate. So thank you for that tonight. Thank you, Joe, for bringing Mr. Bennett to us this evening. Thank you, everybody that stuck with us all the way to the end. We're going to go ahead and close our meeting now. I'll see you back in 4 weeks, November 11th, for our next meeting. Have a great night, everybody.